This is part 4 of our read along. We were talking about Wayfarer does not want all these other lawsuits to be included in the evidence. In contrast to the slight probative value of other lawsuits, the potential prejudice is substantial. For example, among other things, evidence relating to other employment related claims might well mislead and confuse the jury by suggesting that mistreatment of employees is pervasive. We had already read that. So, Lila cannot explain the significance of these other litigations to her case, and the fact that such other litigations exist has no bearing on the merits or lack thereof of her claims herein. Furthermore, the fact that she proffered exhibits refer to allegations as opposed to judgments makes them even less probative. And then there's an example, and it says precluding evidence of existence of other lawsuits because mere allegations of misconduct therein is of little probative value. And then another example in Moore versus Rubin. Courts generally exclude evidence of other lawsuits even if the other lawsuits are related to the case before the court. Oh, or like Figueroa versus Boston Scientific Corp. It says precluding evidence as to 720 other lawsuits filed against defendant medical device manufacturer because the probative value of the fact that approximately 720 plaintiffs have brought suit is substantially outweighed by the danger of unfair prejudice, confusion of the issues, and considerations of undue delay and waste of time. Also, evidence of other litigations will likely confuse the jury and prejudice the Wayfarer parties. B. The court should exclude evidence of related and unrelated lawsuits, including suits involving Melissa Nathan and Jennifer Abel. The general rule against the admission of evidence related to other lawsuits should also be applied to exclude all reference to Jones et al. Oh my gosh! So, Jones versus Abel cannot be brought in? As well as other lawsuits asserting claims against defendants Jennifer Abel and Melissa Nathan pursuant to Rules 401, 402, 403. Oh my gosh, that's right. They were sharing evidence because the cases were linked, but they are no longer linked because Abel has been dismissed. Nathan has been dismissed. Boom, mother freaker. Oh my gosh. Pursuant to Rules 401, 402, 403, the court should preclude these exhibits as well as any reference to those litigations and the allegations therein because such evidence is not relevant to the matter before this court, and any reference to the above referenced exhibits would be unduly prejudicial to the Wayfarer parties. The jury could easily confuse any evidence regarding the merits of the Jones action, which involves some of the same parties and witnesses as this case, or other actions involving Mills and Nathan, with the merits or lack thereof of the case, thereby causing undue prejudice to the Wayfarer parties. Courts routinely exclude evidence relating to previous litigations involving one or both of the same parties, where the merits of those prior litigations would become inextricably intertwined with the case at bar. Accordingly, the court should preclude evidence regarding other litigations against Melissa Nathan or Jennifer Abel, including the allegations therein, whether based in contract or tort, as inadmissible under Rule 403. Oh, look. Motion in Limine. Number 7, to preclude any reference to a surreptitious recording. Oh, the Clara U recording of non-party Steve Sarowitz. Woo! The Wayfarer parties anticipate plaintiff will seek to introduce excerpts of a secretly taped 38-minute recording of an August 29, 2024 conversation between third-party Clara Yube and Steve Sarowitz, in which he states an intent to vigorously defend his studio Wayfarer against any claims brought by plaintiff and or her husband. In the soundbite, Sarowitz states in response to a question from Ms. Ayub about protecting the studio. He said, quote unquote, I will protect the studio like Israel protected itself from Hamas. There were 39,000 dead bodies. There will be 2 dead bodies when I'm done. And so, not dead, but dead to me. You're dead to me. So, that kind of dead, but dead to a lot of people. If they ever get me to that point, then I'll make it worth their while because I'm going to spend a lot of money to make sure that the studio is protected, but I don't think we'll go there. This statement has nothing to do with the merits of the case. The plaintiff has repeatedly quoted this excerpt in its filings with the court and to the press, characterizing it as a threat against Lively and Ryan Reynolds. To create a false impression of the threat, plaintiff has cynically omitted the qualifying phrase. Also, not dead, but dead to me. You're dead to me, so that kind of dead. The recording is irrelevant and that it does not make any material fact of the case more or less likely. I meant more or less likely. The statement does not relate to plaintiff's claims for sexual harassment and or retaliation. If anything, in the full recording, Sarowitz explains that no issues occurred on set. The only purpose of this evidence would be to attack Sarowitz's character and prejudice the jury against Sarowitz and Wayfarer. The soundbite falls squarely within the ambit of evidence typically excludable under Rules 403 and 404. Accordingly, the court should preclude plaintiff from introducing and or referencing Sarowitz's comment to a youth. Yeah, like the gall, like the audacity, because if anybody, Sorowitz has been the one threatened. It's like Uno reverse. Lively's over here like, oh, I'm a victim of Sorowitz. He threatened me. And freaking Sorowitz is the one that had like an arson in his house. And more threats against his family. It's no joke. Anyway, motion in Limine number 8 to preclude evidence of Steve Sorowitz's wealth, financial resources, and the payment of defendants' legal fees. The plaintiff has repeatedly referred to Steve Sarowitz as a billionaire in both court filings and to the media. Evidence of a person's entity's wealth generally isn't admissible because it usually is irrelevant and unfairly prejudicial. That is especially so here, where Sarowitz's wealth is irrelevant to plaintiff's claims. Even assuming Sorowitz's financial condition once had some relevance to punitive damages, he is no longer a defendant in this matter and thus not subject to punitive damages award. Moreover, Sorowitz's financial status threatens to prejudice the jury. In the current political climate, the term billionaire may have a negative connotation to some, perhaps many potential jurors. Balancing the lack of probative values of Sarowitz's wealth with the potential prejudice leads to the inescapable conclusion that such evidence should be precluded. For similar reasons, payment of responsibility for legal fees and costs incurred in the defense of Lively's allegations should be precluded as it lacks any reference to the merits of plaintiff's claims. Oh, motion in limine number 9 to preclude evidence and argument related to Brian Friedman. Plaintiff's 13 cause of action for defamation was based solely on 5 post-litigation statements by the Wayfarer party's counsel, Brian Friedman. On April 2nd, 2026, the court granted summary judgment to defendants on this claim, eliminating any need for testimony relating to Friedman's statements to the media. In contrast, any such evidence threatens severe prejudice to defendants and their defense. First, evidence of alleged misconduct by defendant's trial counsel would tend to undermine his credibility with the jury and by extension erode his client's credibility. Indeed, the only reason why plaintiff would seek to admit such evidence, which now bears no relevance to her remaining claims, would be to poison the jury against defendants by undermining the credibility of their counsel. So freaking sneaky, right? Yeah. Anyway, follow for part 5.